welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the previous week. Let's begin. Matthews J. Nendumpara and others versus Union of India. The Supreme Court upheld the designation of lawyers as senior advocates in this case. Advocate Matthews J. Nendumpara and 7 others filed the petition. They argued that designating lawyers as senior advocates creates a special class with unique rights, privileges, and status not available to regular advocates. The petition challenged Section 16 and 23 subsection 5 of the Advocates Act of 1961, claiming that they violate Article 14 of the Indian Constitution, which addresses the right to equality. Section 16 of the Advocates Act establishes 2 categories of advocates: senior advocates and other advocates. Section 23 subsection 5 of the same Act specifies that senior advocates have precedence over other advocates, and this seniority-based right is determined by their respective seniority. The petitioners asserted that the existence of these 2 categories has resulted in unforeseen problems and inequalities, which the Parliament did not anticipate when enacting the law. The top court's bench, comprising Justice S.K. Kaul, Justice C.T. Ravi Kumar, and Justice Sudhanshu Dhulia, dismissed this petition while holding that the classification of advocates and the mechanism to grant seniority to advocates is not based on any arbitrary, artificial, or evasive grounds. The court further said that the challenge to the classification of advocates being violative of Article 14 of the Constitution is untenable, since Article 14 itself permits the reasonable classification of people by legislature. The court clarified that expertise and merit is the criteria for designation, and the special entitlement to address the court is coupled with many restrictions, which the senior advocates could otherwise perform as advocates. The court also highlighted that after the 2 judgments passed in the Indira Jaising cases in 2017 and 2023 have endeavored to make the process more transparent. X versus Union of India. A bench of the Supreme Court, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice J.B. Pardiwala and Justice Manoj Mishra, dismissed a petition for the termination of a 26-week pregnancy. The bench was under an ethical dilemma about the abortion at this stage that will amount to feticide apparently. However, it was held that the pregnancy will not be allowed to be terminated at this stage, as neither the fetus has any substantial abnormalities nor it is a medical emergency to save the mother's life. The court emphasized that the statutory limit to seek an abortion is 24 weeks, and the requirements of Section 3 subsection 2b or Section 5 of the Medical Termination of Pregnancy Act of 1971 must be fulfilled. The matter came before a 3-judge bench after a 2-judge bench of the Apex Court, comprising of 2 women judges, Justice Hema Kohli and Justice B.V. Nagaratna, had delivered a split verdict in the matter on October 11th. Interestingly, the split verdict came after the same bench allowed the abortion on October 9th. The bench differed in its order after receiving a report from the All India Institute of Medical Sciences, which said that fetus is viable, meaning there is a strong possibility of its survival. The Supreme Court, while reflecting on the issue, said that if the child is delivered at this stage, there is a possibility of it being born with deformities. The court highlighted that in our country, children with special needs are not likely to be adopted, so the child will have nobody. The Women's Council said that she was suffering from depression and is unable to take care of her 2 children. Her children are being looked after by her mother-in-law. The council argued that if the abortion is disallowed, 2 lives will be spoiled. The court, considering all the contentions, noted that stopping the heartbeat of a fetus would significantly affect its mental and physical abilities, although the court granted the right to parents to decide whether to give up the child for adoption. Initiatives for Inclusion Foundation and another versus Union of India and others. A bench of Justice S. Ravindra Bhatt and Justice Dipankar Datta of the Supreme Court issued directions to the principal secretaries of the Ministry of Women and Child Development of all states throughout the country to appoint district officers in every district within a period of 4 weeks to oversee the effective implementation of the Sexual Harassment at Workplace Prevention, Prohibition and Redressal Act, popularly known as the POSH Act, which was enacted in order to protect and remedy women against sexual harassment at workplace. The court expressed its concerns, stating that the failure to notify district officers specifically has a snowballing effect. The complaint mechanism and legal framework, no matter how effective, remain inadequate if the authorities set out in the Act are not duly appointed or notified. Therefore, the state UT government must ensure that every district at all times has a notified district officer. The court said that district officers should receive mandatory training with regards to their role and responsibilities. It was further observed that the centre may consider amending the rules to operationalize Section 26 of the Act by recognizing a fine collecting authority and also identify one department and creating a nodal person post which shall be responsible for the implementation of the Act. The Apex Court made the direction on a writ petition filed by the NGO Initiatives for Inclusion Foundation and others that sought directions to the state and central government to take steps for implementation of the POSH Act of 2013. Supriyo Chakrabarti and another versus Union of India. On October 17 this year, the long-awaited verdict regarding the legal recognition of same-sex marriage was delivered. The Supreme Court addressed various critical questions, including the fundamental right to marry, discrimination under the Special Marriage Act, state regulation of the intimate zone, restrictions based on sexual orientation, transgender marriage rights, and adoption rights for queer individuals. A 5-judge constitution bench led by the Chief Justice of India D.Y. Chandrachud and including Justice Sanjay Kishan Kaul, Justice S. Ravindra Bhatt, Justice Hema Kohli and Justice P.S. Narasimha began hearing approximately 20 petitions on April 18, 2023 and deliberated on the matter for 10 days. The bench ultimately issued 4 separate judgments, with the majority opinion articulated by Justice S. Ravindra Bhatt along with Justices Hema Kohli and Justice P.S. Narasimha, while Chief Justice D.Y. Chandrachud and Justice S.K. Kaul presented a minority opinion. Chief Justice Chandrachud emphasized that queerness is not an urban elite concept and has existed in India since ancient times. He advocated for extending adoption rights to queer couples and criticized the Central Adoption Resource Authority for exceeding its authority and its regulations being deemed unconstitutional. He urged the state and union territories to raise awareness about queer rights and ensure equal access to benefits like ration cards, insurance, employment, pension and gratuity. The Solicitor General Tushar Mehta assured the court that the union government would establish a committee to determine the rights and entitlements of individuals in queer unions. The CJI clarified that the Constitution of India does not grant a fundamental right to marry, but it is up to the Parliament to make changes in the law. Justice S.K. Kaul supported certain rights for queer couples and viewed legal recognition of non-heterosexual unions as a step towards marriage equality. He also highlighted the need for an anti-discrimination law. On the other hand, Justice S. Ravindra Bhatt and Justice Hema Kohli disagreed with the notion that there is no fundamental right to marry. They held that legal recognition of a union similar to marriage could only be achieved through legislative enactments, not through court mandates. Additionally, they disagreed with the CJI on the issue of adoption, stating that removing the term marital from Regulation 5(3) could have unintended consequences and complex policy considerations. Instead, the responsibility was placed on the state to address these issues. Justice P.S. Narasimha concurred with Justice Bhatt and Justice Kohli and dissented from the CJI and Justice Kaul, emphasizing that while the benefits of marriage are fundamental to fulfilling life, marriage itself is not a fundamental right. With that, I, Ananya Singh, thank you for watching Verdictum. For more such informative content, don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal news.